Good afternoon, everyone, and welcome to the Federation of Credit and National Network of Credit and Financial Professionals webinar. Today's topic is using secured transactions to mitigate risk. I welcome all of you on behalf of both associations. This is Yusine Alvarez. I would like to take a moment before we introduce our wonderful speaker for today to just remind everyone of a couple of housekeeping items. We will not be taking questions through the actual presentation, as we have a very large number of attendees for today's session. What we recommend that you do is there's a chat message on the right-hand corner of your screen. You will be able to submit questions through the chat message, and at the end of the presentation, Mr. Jerry Bailey will be able to read the questions, or Sharon, our facilitator, will be reading the questions, and he can answer anything. In addition to that, we will be providing Jerry's email address, so if you think of anything after the presentation, you're more than welcome to reach out to him directly. We also want you to know that in accordance with our mission statement of providing continuing education, we will make this presentation available in a recording, and it will be posted on the Federation of Credit website within 24 hours of today's presentation. Again, I want to thank Mr. Jerry Bailey, and I want to let all of you know that it is because of the generous sponsorship of companies like NCS that we can continue to provide this level of continuing education for credit and AR professionals. So when you're making your decisions, we want you to keep them in mind and make sure that you support our sponsors first. With that, I'm going to turn it over to Board of Director Ken Frisco, who will tell you a little bit about our guest speaker today.
Okay, thank you, Yusine. Our speaker's background, he's currently the Executive Sales and Education Services Manager for NCS and has been with the company since 1995. Prior to coming to NCS, Jerry was a corporate credit manager in the manufacturing industry for 10 years, during which time he gained a very thorough hands-on experience with both UCC filings and mechanics lien filings. Jerry consults with companies daily and has spoken to groups nationwide about Article 9 of the Uniform Commercial Code, revised Article 9, the nuances of construction credit, and the benefits of selling through secured transactions. So with that, I'd like to turn the presentation back to Jerry to start today's broadcast.
Okay. Thank you, Ken, and thank you, Yusine. I'd like to thank you folks for having me in and hosting this. And thank you all for attending the webinar, too. Hopefully you will get some value out of it. But my name is Jerry Bailey. Our topic today is using secured transactions to mitigate risk in our accounts receivable portfolio. And mainly what we're going to talk about is ways to secure the sales that we make on open credit terms through these secured transactions. And secure transactions basically mean we are going to have some sort of collateral pledged against the sale that we make to our customer on open terms. Specifically today, we're going to focus on UCC filings and mechanics lien filings. And if you are familiar with Scott Blakely and Bruce Nathan and Wanda Borges, these folks are the top creditors' rights attorneys in the country. And essentially the phrase they use when you're using secure transactions is that you are backstopping your credit position. Meaning if your customer were to default or file bankruptcy, you're not going to fall back as far as the people who do not secure their accounts receivable. So we'll have other assets pledged against the credit line to protect us in the event of a default. So here's our agenda. Things we're going to talk about. We'll talk about the benefits of being a secured creditor, UCC filings, mechanics liens filings, how to use them, when they might apply and be the best protection for us. But really one of the biggest things we're going to talk about today is priority and the priority of our claims as creditors. Because as responsible credit people, really one of our goals is to put our company in the best possible position to get paid by our customers when there are defaults or bankruptcies. We have a couple decisions to make as trade creditors. I mean, the first is when we entertain a new customer, are we actually going to lend or not? Are we going to extend an open credit line to that customer and sell on some sort of credit terms? Or are we going to sell cash in advance on credit cards or something along those lines? Now, once we've made that decision, we have a second decision to make, because if we decided, yes, we're going to sell on open terms, then the second decision we have to make is, are we going to sell on open terms on a secured basis or an unsecured basis? And based on how we make those decisions, that's going to establish priorities. And a couple different priorities really get established. The first priority that gets established is, how would our claims be ranked, and what would the priority of our claims be as creditors in the event that the business fails? That's one priority that would get established. The other priority would get established is, how are customers going to pay their bills? Because debtors tend to pay secured creditors ahead of the unsecured creditors. They recognize that there's a larger consequence if they default on a secured debt versus an unsecured debt. So those are some of the things we'll talk about today. Basically, again, ways we can bolster our credit position in the event our customer defaults or files bankruptcy. Now, when we talk about this idea of security or having collateral pledged against a credit line, really, we're talking about a couple different ways. One, we can have our customer pledge personal property to us against the credit line that we extend to them. Now, what's personal property? Well, personal property is the assets of our customer, their accounts receivable, their inventories, proceeds they get for selling the inventories, their equipment, mortgages, chattel, contract rights. All of those things are the things that we have the opportunity to have pledged to us against the credit line we extend to our customer. That's accomplished through the UCC filing process. Now, the other side is real property. We have an opportunity to take security against real property as well, too, and that's accomplished through the mechanics lien filing process. That occurs when we have improved a piece of real property, like a building. And the theory there is very simple. We have made a permanent improvement to this piece of real property. The owner should not retain the benefit of that improvement unless they pay us for it. And if they do not, we have the opportunity to take collateral or security against that piece of property to whatever extent we have improved that piece of property. So we have those two ways as trade creditors to try and get at assets when our customer defaults. But really, there's three ways to garnish assets in situations like that. There's those two ways. And then the third way is to litigate, to sue and get a judgment against our customer. Now, of those three ways, obviously litigation is far and away the most expensive and the most time-consuming. We've probably all been through scenarios where we had to sue a customer, we got a judgment, and then we went to look to our post-judgment remedies, and we still didn't get anything. And we may have spent a lot of money to get that judgment. And that's really why secure transactions were created. One of the goals was to try and create a system where there would be a priority of our claims as creditors established without all of us having to go to the courthouse and sue one another. And they hope that, in theory, that the secure transaction possibility or system would make the credit transaction cheaper. They want to make the credit transaction cheaper for both parties, cheaper for the lender as well as the borrower, cheaper for the creditor as well as the debtor. And the logic was, if the credit transaction is cheaper, more people will sell stuff on open terms. That means more people will buy stuff on open terms. That means more people will buy stuff, and it will drive our economy, and our economy will flourish. It's worked pretty well, really. If you look at countries that have secure transaction systems over countries that do not, the GDPs for the countries that do tend to be about 30% higher at least over the countries that do not. So this has been a very good concept, an idea that has helped us drive our economy. Now, when you look at a world of banking, you can see pretty clearly how they associate the value of selling with collateral pledged versus selling without collateral pledged. Contrast the difference of the interest rates of things that they do. You know, look at mortgages. I haven't looked, but I think they're 3.5%, 4% now, versus credit cards are 14%, 18%, 24%, 28%. Well, why? Why is one 4% and the other is 5 times that? The answer comes back to collateral, security. The bank has a piece of property to repossess and sell off in a mortgage situation. They can sell it off and come out whole, maybe even profitable. With credit cards, they're going down for the entire balance. They don't care, though, because they're still very profitable because of the extreme interest charges that the majority of people using those credit cards are paying. But you see pretty clearly how banks associate the value of lending with collateral pledged versus lending without collateral pledged. Banks are really good at lending. They lend a lot more than we do, more often at larger dollars. You can always get more money from a bank if you pledge collateral than you can if you do not. If this idea makes sense for them somewhere, it's probably something we should look into as trade creditors to see if it fits into our business somewhere. So we'll talk about these priorities, how we're going to mitigate risk in the event of defaults, bankruptcies, and things like that too. But within that world, we're also going to try and look and see how can we make ourselves a larger priority for our customer? How can we move up so when they have money, we are the ones getting paid? I learned pretty early in my credit career that the problem with most debtors isn't that they don't have any money. The problem with most debtors is they have $10,000, but they owe 15 people $1,000 apiece. So our goal as credit managers is to make sure we're one of the 10 of the 15. Now, how do we do that? Well, maybe our business is so important to our customer that they have to buy our stuff and they have to pay us first. That'd be nice. But most of us are not in that credit catbird seat. Maybe it's a relationship. Maybe they like our salesperson because he takes them golfing once a quarter. Maybe he likes us better than the other people that are calling him for money. Maybe that relationship gets us paid ahead of other people. Maybe it's the fact that we've served a preliminary notice on a construction project and others have not. Maybe it's the fact that we have filed a UCC purchase money security interest that says, look, we can come and repossess our goods from your place of business if you don't pay us. Maybe that moves us up into the 10 of the 15. Maybe it moves us into number 1. So maybe those are some of the ways that we can make sure that we are in an increased priority position for our customer when they're looking to pay bills. So we all know, too, unfortunately, in the next couple of years, there's going to be bankruptcies in the world of our debtors, or in our account receivable world. The problem is we have no idea. Are there going to be few, some, many? Or is it going to be a small customer? Is it going to be a really large customer? We just don't know. And again, our responsibility as credit managers is to try and protect our companies from those sorts of risks. Our credit policies become paramount in protecting our companies from the really big hits that are going to leave a mark, affect our profitability, drive our stock price down, maybe pull us under as a company. So that's our responsibility. Again, we know there's going to be bankruptcies. We just don't know where. And that's why we're going to put these into place. They're going to prevent some write-offs for us because we're going to get paid in some scenarios where other people do not because we're secured. It's going to reduce our DSO. It's going to improve our cash flow and improve our working capital. Now, we'll talk about UCCs for a little bit here. UCCs fall under our Uniform Commercial Code, and specifically they fall under Article 9 of our Uniform Commercial Code. And, Article 9 in the Uniform Commercial Code was put back in place in the 50s. And I think it's important to understand really why they were put in place and understand the financial landscape back then of when they were put in place. Recognized back then, selling between states in the United States was very much like it is today between countries. There was a lot of apprehension. If I'm in New York selling into New Jersey and my customer doesn't pay me, what do I do? Do I sue them? Well, where? So how? I don't know their laws over there. I'm just going to stay here in my state. You know what? I'm more comfortable in my own living room. That works for me. So that was the goal of the Uniform Commercial Code, was to try and take down those apprehensions and encourage companies to sell and promote commerce and foster a lending environment. It's worked pretty well. The other thing Article 9 is important to understand is Article 9 is not a law. It is a set of guidelines put together by the commissioners on uniform state laws, and they sent it to the states and said, hey, we're recommending you adopt this process. We think it does drive your economy, foster a lending environment. We think this is a very good tool for our commerce. And all of the states adopted it in various forms. There have been some changes made to it, but from one state to the next, they adopted it into law, and some of the states have made their own little nuancy things. So there is some state-to-state differences that we have to understand. The way they index the filings, the filing systems that they use to process the UCCs can vary from state to state. But our Article 9 was a very good piece of legislation. For one thing, it did two very good things. One, it established a priority of our claims as creditors and how those claims would be retired in the event that we had to dismantle a business because it failed. So we could establish that priority without spending all of that money and going and suing people. That was good. That seemed to encourage lenders. The other thing it did was it said we're going to make a public registration of these secured interests too. We're going to file these UCC1 financing statements to make public registrations, and the reason being potential lenders who are looking to sell to that customer on open terms or lend money to that customer deserve the opportunity to go do a search and see how many encumbrances and the nature of the encumbrances are against a given business. And that would allow them to make better lending decisions. It would make them feel more confident or less confident. So it was a good piece of legislation. It's been very well written. It's been effective. It's been well used, and it's been imitated. So those are all very good things to tell you. Article 9 of our Uniform Commercial Code was a pretty good piece of legislation. It has spun out into the world. Other countries are adopting secure transaction systems. Canada, Mexico, Puerto Rico, Australia, New Zealand. The United Nations is backing this idea now. So again, it's not just a United States thing. There's opportunities in other countries for us to take security. But what is this UCC and what is a secure transaction? Well, it's not a guarantee we're going to get paid in full every time. It's not a panacea. It does tell us we're putting ourselves in the best possible position to get paid. There's going to be some situations where we may file a UCC against somebody and we don't get anything just like everybody else. When I was working in credit management, my logic was always, look, I know that's going to happen. There's going to be times where I have a UCC and I don't get paid everything just like everybody else. But if I don't try and take security, I'm conceding that I'm not going to get anything when this stuff breaks down. And that was my logic. It does put us in a better position. There's going to be situations where we get paid and others do not because of our security. And there's going to be situations where people get paid, but we get paid more because of our status as secured creditors. Why would we do them? Well, one, it gives us secured creditor status in a Chapter 7. When there's a liquidation, there is the claims are retired in order of the UCC filings. They pay out the secured creditors first. And then once that's done, then the unsecured creditors split up whatever's left over. So whenever you've gotten 20 or 25 cents against your dollar in a bankruptcy, you basically split up with all of the other general unsecured creditors everything that was left over once the secured creditors were paid in order of their filings. We can give ourselves the right to repossess our goods with a purchase money security interest. That's a pretty big right. If our customer defaults, we can go take our stuff back. We're part of the secured creditor team in a Chapter 11. Normally there's going to be a plan submitted. It's going to call out 2 ways debt will be retired, secured debts and unsecured debts. We'd rather be on the secured lender team. We're generally protected from preferential payment suits. That can be a huge protection. There's nothing worse than going through a bankruptcy. You're owed $10,000 and you say, this is great, we dodged that bullet. And then you get that letter that says, yeah, but you got 2 payments for $30,000 apiece in the last 90 days, send them back in. Section 547C3 and 5 of the Bankruptcy Code tell us that the trustee cannot avoid a transaction that creates a secured interest. That's a big protection. This is one we hadn't realized, but we've had several clients come to us and say, boy, we just had this. Our customer was trying to sell their business, and we didn't realize they were trying to sell their business. However, we had a UCC filed, and we got a call from the president or their attorney or whomever saying, wait a minute, we have to make this debt go away, this UCC go away before the sale goes through. How can we do that? Do we need to pay you out? That can be a very big protection when your customer might be looking to sell that business. With UCCs, there's 2 different ways really we would look to file, 2 different types of filings. There is a blanket or a basic UCC filing. That is one type. The other type is a purchase money security interest. The first type, the blanket, basically is called a blanket because that's what it does. It lays down over all of the customer's assets. The creditor files this blanket UCC filing against all of the assets of the debtor, and the filing covers all of those assets. And the priority is very simple with a blanket or basic UCC filing. The priority is first in time, first in right. Whoever files their UCC first gets paid first, whoever files their blanket second gets paid second, and so on and so forth down the line. So with this, the priority is very easy. It's determined by the date of our filing, and our filing is going to cover all of the assets of the debtor. So in the event that the debtor were to default or file bankruptcy, and they had $61,000 worth of assets, those $61,000 worth of assets would get liquidated, and down the line they would go. So they would pay the bank, number one, second secure creditor, third, fourth, fifth secure creditor. We had $61,000 available, $55,000 were paid to those 5 secure creditors. That means the unsecureds would split up the $6,000 pro rata based on what they were owed. But that introduces us to the idea of priority, and really that's one of the most important concepts. There's 2 ideas here. The first concept is becoming a secured creditor. You know, getting a security agreement signed, filing a financing statement, becoming a secured creditor. That's the first concept, one. Concept 1A within that idea is what is the priority among the secured creditors? Because there is a pecking order. Claims are paid based on where they are situated on the claims priority ladder. Priority is essentially how the bankruptcy courts are going to decide who is going to get paid and how much they're going to get paid. Our pyramid, you can see the kings of the hill are the secured creditors. They get paid ahead of anybody else. Now, we're not going to trump a federal government's tax lien, but by and large, we're going to trump everything else. Because as you move down the line, you have the administrative priority claims. The administrative priority claims are people who administrate the bankruptcy, like the attorneys, and the trustee is actually going to fall below us as a secured creditor. Critical vendors would fall into those administrative priority claims. And below that is the lower level priority claims, which would be the employees and wages and things like that. And then below all of those are the pre-petition general unsecured creditors. And that's where we've been when we got our 25 cents and $1. So you can see really there were a lot of people paid ahead of us. And we were probably pretty fortunate to get to 25 cents on our dollar. Again, as responsible credit managers, our job is to make sure we try and move as high up this pyramid as we can and put ourselves in the best possible position to realize the most money we can in a default. Now, I say that because with a blanket, priority is easy. It's first in time, first in right. It's based on the date of the filing. Purchase money priority is a little different. With purchase money, we're going to be able to take first priority in our goods. We're going to be able to move in front of everybody else that our customer has sold to, our customer has bought from. Everybody that's sold to our customer in open terms, anybody else who has lent money to our customer, anybody else that has filed a UCC against our customer, we're going to have the ability to move in front of all of those folks via our purchase money security interest. So we can take a priority ahead of all of those people. That's accomplished a couple of different ways. But what would be the ideas behind this? Well, if we sold some stuff on open terms, A, and B, we would have an interest in taking that stuff back, then this purchase money security interest would be a pretty interesting tool for us and probably a pretty good tool. So we have the opportunity to take first priority in our goods. Now, under Article 9.102, where the definitions are, there are 2 subcategories of goods. There is inventory and equipment. And we establish priority in inventory differently than we establish priority in equipment. So we need to know, are we selling inventory or equipment? How do we know? Well, Article 9 says it depends on what our customer does with the goods that we sell to them. If we are selling tangible goods to our customer and our customer is reselling those goods to other entities, then we are selling inventory under the definitions of Article 9. And if that's the case, the way we establish priority in our inventory is We do a search to find all of the other previously secured creditors, and we send notification to them, make sure we have proof of delivery of those notifications, and we have moved in front of all of those people. That's if it's inventory. We search and notify. If we're selling goods to our customer and our customer uses those goods in the course of their business, well, in those cases, we don't need to search and notify to establish priority. We must, however, make sure we adhere to the 20-day rule. The 20-day rule tells us we have to do our UCC filing on that equipment within 20 days of our customer's receipt of that equipment. So we don't want to miss. We can do the filing before we ship. We're certainly fine there. Really, as soon as we have an agreement signed and we can describe the collateral, we can do our UCC filing, but we don't want to miss and file on day 21, or we're jeopardizing having first priority in our equipment. So inventory, customer searches and notifies. The customer resells the goods, we search and notify. Equipment, customer uses it, we want to hit the 20-day window. Now with purchase money, again, it gives us first priority. So in our previous example, if our debtor had been worth $61,000 and we had $5,000 worth of equipment in his place of business and we had done a purchase money security interest filing, we would have first priority in that $5,000. We would take it out. They would then have $56,000 to liquidate, and then it would be paid in a first in time, first in right basis. So PMSI, again, gives us first priority in our goods ahead of anybody else. Anybody else that's lent to our customer, anybody else that's sold to our customer in open terms, anybody else that has filed a UCC against our customer. Now, what's the value of this PMSI and repossessing stuff? Well, one, can we resell it? Are the goods that we sell to customer A generic enough that we can take them back and sell them to customer B, C, D, E, and F? If that's the case, then this whole resale thing looks pretty attractive. That's very practical for us. If it's not, if the goods we sell to customer A are only usable by customer A, now resale is not very attractive. We can bring the stuff back and sell it for scrap or what have you, but it's not as much of a value to us and not as attractive in that instance. How about differentiating our receivables, though? How about the ability to tell the customer, look, we can pull our equipment out of there that you're using to make your products. We can pull our inventory out of your business. We can cause a hiccup in your ability to run your business. If you do not pay us, we have the right to repossess. Maybe that differentiates us from the other people that they owe money to. A couple examples. I was at a meeting with a company in Minneapolis, and they made the little insignias on behalf of Lennox and Carrier and Trane and air conditioning companies. But they didn't sell them to Lennox and Carrier and Trane. They sold them to a company that made air conditioning sleeves. And the company that made the air conditioning sleeves then stuck the insignias on the air conditioning sleeves and sold the branded air conditioning sleeves to Lennox and Carrier and Trane. But the insignia people were having a miserable time getting paid by the air conditioning sleeve people. So we sat down, they said, we're worn out. We want to do UCC filing on these people. Which kind should we do? We said, gee, do we do a blanket or a PMSI? And we were like, well, gee, why are we going to do a PMSI? That seems kind of a spiteful repossession. What are we going to do, try and find somebody else named Lennox and sell these things to? But then we said, wait a minute, what about if you repossess these insignias and take them out of their place of business? Well, we all know what our salespeople will say. Oh, they'll just go somewhere else and get them. Well, will they? I mean, what's all involved there? Okay, well, they have to spec this part, put it out for bids. Some potential vendors are going to bid on it. Then they're going to go through the pricing and the bids and select a new vendor. And then that vendor actually has to ramp up production and ship something. I mean, how long does all that take? 3 weeks, 4 weeks? So do you think air conditioning sleeve people are going to go to Lennox and say, hey, no biggie, we just can't ship you anything for the next 4 weeks because we didn't pay the little insignia guy? I don't think so. I think the opportunity there to disrupt that whole process is going to make me one of the 10 of the 15. It's going to move me to the front of the line. Another one that was local to me, too, there was a sports bar by us where we used to go and watch the games. And my friends went in there one day and said, hey, we were in there. They're not closed, but they said they can't serve us beer, wine, or liquor. And I said, well, that's odd. Why? And they said, well, they said that the building changed hands, and the new owner said that the old owner had had some improvements done, and he hadn't paid the electrical contractors, and they had filed a mechanics lien against the property, and because of the mechanics lien, he could not renew the liquor license. And I knew all that because we had filed the mechanics lien against the property here at NCS. And I thought, well, that's odd, because I looked, and in Ohio, you have to renew your liquor license every year. And the mechanics lien had been in place for 3 years, so it didn't make sense. They wouldn't have been able to renew the liquor license the first year. So we did some investigating, and we found out that what had happened was the new owners had borrowed a couple $1 million from the bank, and the bank had said, here's what we want as collateral. We want your liquor license. And that's what they took as collateral. They defaulted on the loan, and the bank said, whoa, cough it up, give us your liquor license. And I thought, boy, that is a really nice piece of leverage. The bank doesn't want to buy and sell the property. They're not realtors. They certainly don't want to try and run a sports bar. They want to get paid. And I thought, that's just a nice piece of leverage. If you have a sports bar that can't sell beer, wine, or liquor, there is your place. So again, how do we create the leverage to make sure we're one of the 10 of the 15? In this instance, I thought it was really well used by the bank. In order to file a UCC, we have two components, two things we have to put in place. One is a security agreement where the customer is going to agree and grant us the secured interest. The other is a financing statement. Before I said we're going to have a public registration, a public record of these liens, these encumbrances. That's accomplished by the financing statement or the UCC1. They're synonymous. But the security agreement is really where we're going to be granted this. It is a contract between us, but it's a contract like a credit app or a purchase order. It's going to spell out terms and conditions. It can exist as a standalone security agreement. Some people like to present that to their customer. They believe presenting a standalone agreement conveys a larger obligation to the debtor to pay them over the others. That's perfectly fine. Other people do not. Other people say, we're already getting a document signed like a sales agreement or an installment note. Let's just put the verbiage into that. And once we get that signed, then we have been properly granted this secured interest. Some people put the verbiage in their credit app. A CASA, a credit application security agreement. Once the customer signs the credit app, they then have been granted a secured interest. They don't have to file. It means they can file. Some of our clients do this, and then they set a threshold, $10,000. And the customer goes along for 2 or 3 years and doesn't crest that $10,000 credit line, then they're fine. All of a sudden, they get a big order in over the $10,000. That trips the switch, and they go ahead and file the financing statement. But that's the first step, this security agreement in whatever form we decide. Then we have to make the public record. This is what makes it the public record. The financing statements are in place for 5 years, by and large. Wyoming is 10, but 49 of the states, the financing statements are in place for 5 years. At the end of 4.5 years, we have a 6-month window to renew that financing statement, or it's called continuing it. And we don't need our customers' involvement at that point in time. We can just go ahead and continue it for a new 5-year period. We used to have to file these things anywhere the customer had goods. We don't have to do that anymore. We just file one time in the state where they are located based on their form of business, typically wherever they're registered. If a corporation, we're going to file in their state of incorporation. We file electronically. We didn't used to. We used to actually send a form in. It seems very archaic now, but the good news was when we did that, there was a process of review. And if we screwed something up, they rejected it and sent it back to us. They don't do that anymore. Whatever we send out there is going to get recorded. We can type gobbledygook into a financing statement. It's going to take it out there and be recorded. And we have to be aware, the states do index these things. Some of the things that have knocked people out, when there is a financing statement filed, if the debtor files bankruptcy, the way they're going to determine who the secure creditors are is they're going to do a search, and they're going to use what's called standard search logic in that particular state's computer systems. The problem is the standard search logic from one state to the next is very different. So that's problematic. The way that it would search in Pennsylvania is different from the way it would search in Delaware. So, I mean, this was Nebraska. The debtor was EDM Corporation. 3 banks filed. Hastings State Bank filed first. However, they listed the debtor name as EDM Corporation, DBA EDM Equipment. EDM filed bankruptcy. They did the search. Unfortunately, in Nebraska, that DBA EDM Equipment constitutes what are called noise words. That knocked it out of standard search logic. The filing didn't come up. They were deemed to be unsecured. This was in Utah. The debtor was KWM, all with periods, and the financing statement was filed without the periods. Search logic did not find that. They were deemed to be seriously misleading too. Seriously misleading means you think you're secured, but you ain't. So, how do we do these things? Where do we put them in place? Well, that's always the question. As credit managers and as trade creditors, we would prefer to be secured on every sale ever. And our salespeople would probably prefer that they actually strike the word secured transaction from the dictionary. So how do we determine where? We're not going to file on everybody. That would be crazy. Filing on nobody doesn't seem to be very responsible either. So how do we do it? Well, the first thing we have to do is realize that there's two different arenas of customers. One is new and the other is existing. New customers are a little easier. We can play it off as part of our corporate credit policy. This is required by our bank. We can play it off that way. Maybe we offer it to new customers like this. This is what banks do. You can get more money if you pledge collateral than you can if you don't. We'll give you up to $20,000 on an unsecured basis. If you want more than that, we're going to ask for security. Maybe we have some sort of credit scoring models that, that tells us what the risk level is. If they fall outside of that risk level, that's where we file. Maybe we tell them, look, we can get you a credit line more quickly if you grant us a secured interest versus if we have to do the full bore investigation, it'll take a little longer. Maybe discounts. Maybe everybody wants always a discount. They want their 2% 10 net 30. Maybe that's the first step. In order to be eligible for discounts, you have to grant us a secured interest. So that's maybe some of the ways we look for existing or for new customers. For existings, it's a little different. For one, with existing customers, if we have somebody that's paid us like clockwork for 20 years, we're not going to think about approaching them to take security. That would just be a faux pas from a customer relations point of view. However, not everybody pays us like clockwork for 20 years. So there are some opportunities. One, maybe the customer requests extended terms. Our terms are 30, they want 55 days. Okay, we'll do that, but we're going to ask for security. The customer has passed terms. They're behind. So maybe that's the way we make it palatable for them. Maybe they're always banging up against the ceiling of their credit line. They're kicking out on credit hold every day. We have to manually put the orders back in. It costs them 2 or 3 days delivery time. Maybe the way we solve that is to say, look, we'll expand your credit line. All we're asking is that you sign this security agreement. Anytime we restructure debt, maybe somebody needs help, we put an installment note in place. We make sure we take security and file the financing statement. Customers' financials are declining. They don't support the credit line anymore. That's a good opportunity. Or we get a really big order from an existing customer that's well out of their norm. That's an opportunity. But really, it was put to me very simply by someone who was in one of our presentations, and the people that work for her said, when are we going to look to do this? And her answer was very brilliant. She said, anytime somebody asks for a favor. So what do? We have a UCC in place. How do we use it to get paid? Well, first of all, we have some opportunities through Article 9. One, we can declare the debtor in fault. We have to tell them, look, you're in default. We're going to come over. We have a purchase money security interest. We're going to come and get our stuff, cease and desist selling the inventory or the equipment. We give them a cure period to say, look, we're coming over in 10 days if you have not paid. The courts love a cure period. So we've given them a cure period, told them when we're going to come over, tell them to have the stuff waiting for us, and also inform them that, look, part of the process is when we do this, we have to send a notice of disposition of collateral to all the other secured parties, which is going to include your bank. They're going to find out we're pulling our UCC filing. I don't think they're going to react very well. We'd rather not do that, but it's required. Hopefully that will spur them into payment where they're going to think, I don't want that going to my bank. Who knows how they'll react. So we send this out and try and spur them into payment by this default letter. If that doesn't, now we have to look to our rights. We can go get our stuff and we can use self-help, meaning we don't need the courts. We could just go get our stuff as long as there's no breach of the peace. So if they tell us, well, come on over, we'll meet you with a shotgun, well, then we're probably going to need to go to the sheriff or a judge and get some judicial help. But if it's self-help, we can go get our stuff. We don't need any of that. The code oddly tells us we can't breach the peace. However, recovery through stealth or deception is permitted. So you can tell this code was written by politicians. What happens with the stuff that we take back? How do we pay out on this? Well, we take everything back, and then there is a pecking order of how we pay things out. One, we have to pay any repossession and storage costs. So if we needed to lease a truck to go get it, we have to pay the trucking company. That's first. If we needed judicial process, we have to pay any attorney fees. If we use self-help, that step goes away, so we won't have that. And then we satisfy our indebtedness. Whatever we're owed, we take. And then we pay out anything over and above. If we were able to collect more than we were owed, then we pay that to other parties with an interest in the collateral. Now, that's what we do with tangible goods. Here's one of the things we can do with intangible stuff. Our customer is not paying us. Article 9 tells us upon default, a secured party may notify an account debtor to pay the account directly to the secured party and not the debtor. In addition, the secured party may collect proceeds to which it is entitled under 9315 and may commence legal action against third parties to collect accounts and other obligations. That tells me I can instruct my customer, if he is not paying me, to have his customers remit directly to me, and if they do not, I can sue them. Now, am I going to do that? I don't know if I'm going to sue his customers. Am I going to tell my customer that I'm going to do that? Heck yeah. I'm going to let him know. I'm going to send him this section of the code and let him know to get him to start paying me. Because, again, I think that's going to make me one of the 10 of the 15. That might move me up to number 1 of the 15. Now, other risk mitigation tools, if you are one of the lucky individuals that is working in the construction world where you are providing goods or services that is contributing to the improvement of a piece of real property. And again, real property would be a building, roads, things like that. We're contributing to the permanent improvement. We have the opportunity to take collateral or security against that piece of property via the mechanics lien statutes. We can secure ourselves to whatever extent we have improved that piece of property, provided we do what is required by that state statute. Mechanics lien laws are state specific, and there is massive diversity from one state to the next. One of the biggest things I think to recognize in the lien process is it's not a process where we sit back and file a lien if we're unpaid, where we look at our AR and say, gee, we're at 70 days, let's go ahead and file the lien. We need to start to pay attention to this far earlier. Most of the states, the lien process is a 3-step process. There is some sort of a preliminary note, and these timeframes are examples. We just pulled from a couple different states. Don't take them as gospel for your state. But most of the states have some sort of notice that we must do up front where we are alerting the owner that we have improved the property, and it can be done very early in the process too. California, 20 days from first furnishing is when we must do this notice. Our money is not even past due. It's still in the current column, and yet there is something we must do to preserve our right to file the lien, because the states outline that these are prerequisites that we must take in order to be able to take the next step. So if there is a preliminary notice required, we must serve it in the time frame allotted to preserve our right to actually file the lien if we're unpaid. And then if we're unpaid, then we go ahead and file the lien. The states normally base the notices on so many days from first furnishing material or services, and then they move on to giving us so many months or so many days from last furnishing to file our lien. Normally it's 90 or 120 days from last furnishing they give us to file the lien. And if we don't do it in that time frame, we lose that right. And then the statute would further tell us we have so many days or so many months or so many years to sue against that, to foreclose. And if not, we must foreclose against the property, file suit to foreclose, and they have to sell the property and pay us out of the proceeds. So it's important that we know the laws in that given state and recognize what do we need to do and how early do we need to react, because probably a third of the states tell us we have something to do in less than 45 days, I would say is, I don't think anybody gets paid in less than 45 days in the construction world. So about a third of the states, really, when we get an order or a subcontract, we need to sit down and say, are we going to serve our notice and preserve our lien rights or not? Because, again, we can't sit back and react and make the call then to say, oh, gee, we're at 70 days, we're unpaid, let's file the lien. We may have lost that right. So this notice is a good thing, too. I mean, think about it from the owner's standpoint. There's lots of people that can file liens against the owner's property. Unfortunately, he just doesn't know who all of them are. So this notice is the way that all of those potential lien claimants identify themselves to the owner, and he tries to make sure they get paid so they do not file liens against his property. So we're down here as a material supplier providing windows or electrical or what have you. We send the notice to the owner that says, here you go. We just want to let you know, one, we're complying with the required steps in the state. Two, we want you to know that we contribute to the improvement. Look out for us and make sure we get paid. And the owner does. And essentially what he does is he builds a roster of potential lien claimants every month when he gets a draw from the general and just matches up and says, okay, I got a lien waiver from these folks. I got a preliminary notice from these folks. Yes, I got a lien waiver from these folks also. I got a preliminary notice from the electrical people. Yes, I got a waiver of lien from the electrical people. Okay, I've gotten waivers of lien from everybody I've gotten a preliminary notice from. It looks like everybody's been paid. Good to go, general contractor. Here is your check. Thanks. But if we don't serve our notice, we're not getting on that roster of potential lien claimants, and we can slip through the cracks. We cannot get paid, and from the owner's standpoint, even worse, we can file lien against his property. So we want to know the laws. When are they required, and make sure we are doing our notice within time. Why do people do mechanics liens? Well, one, it allows us to factor additional non-customer assets into our lending decision. Frequently in construction, the problem is I'm looking to extend a credit line to my customer, and it can be 5 to 10 times their net worth. Any normal credit evaluation, we would say no. But if we can tie back to the piece of property, then we can say yes. Makes this a greater priority for payment by our customer. It is going to affect our DSO. If a general contractor has enough money to pay 2 subs, but he owes 3 subcontractors money, and this sub has done their notice, and this subcontractor's material distributor has done their notice, I guarantee the general is going to pay that sub, and he's going to pay that sub, because he knows if he does not, again, there is a greater consequence. A lien gets filed against the owner is going to come down on the general contractor. We always talk about robbing Peter to pay Paul. Think of it this way. I served my notice, I'm Paul. I served my notice, I'm Paul. I didn't serve my notice, I'm Peter. In our studies here, we've determined, 96.5% of the time, if you serve your notices, you're going to get paid. Another 2.5% on top of that, if you file the lien, 99%, you're going to get paid. And then 1% of the time would you ever have to go to foreclosure to file suit. So recognize the majority of time, we have a client that told us they put a consistent process in to protect their lien rights, and they dropped their DSO by 30%. You can imagine the difference that makes to your working capital and how much more profitable you can be as a business. Additionally, it identifies us to the property owner, who then makes sure we're going to get paid before he releases more funds to the general. It provides us the opportunity to encumber the improved property in the event of non-payment. So if we don't get paid, we can file this lien against the property. That's going to cause some problems. It's going to cloud the title of that property. The owner is not going to like that. They're going to make sure that we get our money and this lien gets removed. Makes a public record of our debt also in case the owner tries to sell this piece of property. So that's the benefits. We can also use these lien deadlines too as ways to make sure we're getting paid. We can calculate the exact deadlines of when that lien is going, our lien deadline is coming due, and let the customer know, look, our lien deadline is the 3rd of August. We're going to send this out a week beforehand if you don't pay us. That tells our customer, look, they're serious. They have this whole thing in the crosshairs. We need to come up with a way to file to get some money to pay them. I think that moves us into one of the 10 of the 15 ahead of the people that cannot make that statement. That is the presentation. Let's go ahead and see what we have as far as chat. See if I can figure out how to work this.
Okay, Jerry, Rob posted in the question box, credit card interest rates are not 4 times mortgage rates solely due to collateral. They are 4 times mainly due to the high legal limit on credit card interest and the lack of bargaining power of individuals to lower that rate.
In some cases, sure. I would offer you go to any bank and pledge collateral. Your interest rate is going to be lower than if you do not, on whatever it is, whether it's a credit card, whether it's a loan, whether it is a mortgage. I would offer if you pledge collateral, the interest rate is going to be lower than if you do not. But thank you.
Okay, and Jerry, there are no more questions at this time. If anyone does have any questions, I will provide Jerry's email when I send the PDF version of the presentation. We are going to close today's webinar. I would like to thank Jerry Bailey for taking the time to present to our group, and thank all of today's attendees for taking the time out of their day to join us. Thank you all again, and we look forward to seeing you at our next webinar.
Okay, thank you, everyone.